Good morning, everyone, and thank you very much for joining us this morning. I'm Lily Oliver. I'm a partner in the regulatory team based in our London office. In an environment that changes not just on a daily basis, but depending on which government minister is in front of the camera, those within all sectors of the industry are looking for clarity and certainty to enable their businesses to function safely within the law, which is the reason why we've come together today and why we have arranged for this expert panel to consider the hot topics that concern you, your clients, your businesses as things stand today. I'm delighted to therefore introduce the panel, which consists of Malcolm Galloway, Senior Member of Crown Office Regulatory Team, which is the leading regulatory chambers in the country. Malcolm also sits as a part-time Crown Court judge, so he'll be able to provide insight into the challenges for the criminal court system. Also delighted to welcome our own senior partner, David Lewis, who also sits as an assistant coroner. And finally, partner and head of regulatory, Dowie Thomas. Thank you all for joining us today. It's a real shame that the 150 so of us that are here today obviously aren't in person, and there are therefore slight limitations in terms of how interactive this session can be. But please do use the chat function within the system if you're having any difficulties in hearing us, and equally please do put forward any questions through the questions function, and we will do our best to get through as many of them as possible. Gentlemen, perhaps we could begin by giving a bit of an overview in terms of what your forecasts are for this short and long-term future in these challenging times. Dowie, we'll start with you, please.
Thank you, Lily. Good morning, everyone. I hope you can hear me okay. Welcome to the webinar. Thank you for so many of you for joining us. As Lily says, I have the privileged position of being the head of regulatory for Waitmans. I just want to talk briefly on where we are, Lily, if that's okay. There's been a lot of confusion since Matt Lucas did the best impression of Boris Johnson I've ever seen on Sunday night after his fairly surprising and somewhat vague announcement. And if anyone hasn't seen that Matt Lucas video, take 20 seconds to have a look at it. It's absolutely brilliant. But since then, we are in a much better position to understand what is expected of employers during that return to work phase, that mobilisation back to the workplace. I just want to touch briefly on the law as it stands in light of what's happened over the last couple of days. I know that Malcolm's going to give some practical tips to help employers and employees with the practicalities of what is now expected. We have now clear guidance for 8 sectors of the economy as to what is required to mobilise safely in a COVID-19 secure way back to work. It is guidance, and people have already asked before this webinar, is it law? Is it enforceable? What is guidance? Well, there has always been guidance accompanying health and safety law. The HSE have always produced guidance. They've produced something more formal than guidance as well, called Approved Codes of Practices, or ACOPs, and they haven't done that yet. But the guidance that we've got is not law in and of itself. Not following the guidance is not a breach of the law in and of itself. The reality is, though, the guidance is there to be followed unless there are exceptional reasons not to follow the guidance. And just to give an example of how far we've come, in 2003, there was a guide to businesses around infection control in the workplace, so 17 years ago, and it said, although your employees may well pick up infections from workmates, just as they might do from outside of work, those infections are not your responsibility under health and safety law. Now, the reality is COVID-19 is brand new. There is no precedent for it. And the reality is we have to manage this risk in a way we've never managed infections before. So this is absolutely part of a responsible employer's duty to manage the risk of COVID-19 in the workplace. The practicalities of that are difficult. So social distancing in the workplace will have to be considered in detail. That will have to be part of what's called this COVID-19 risk assessment that all employers are required to undertake. The law underpinning that hasn't changed. None of the law on health and safety has changed as a result of COVID-19, but there has always been an obligation on employers to undertake a risk assessment. For most businesses, that will require a written risk assessment. And for businesses with 50 or more employees, that risk assessment will now need to go onto their website and be published. So this will be a visible, accessible document. It needs to consider a whole range of things, areas of people's lives that we've never thought about before. And just briefly, I'm conscious there are lots of people from different sectors and segments of industry on this webinar, but we have taught ourselves as employers not to think about gender, not to think about disability, not to think about location or ethnicity, and not to identify those as reasons to do things different with people. Actually, we need to realise that those are bigger risks than ever before. Males are much more at risk than females of contracting and sadly dying from COVID-19. So are those with disabilities. At the moment, those in the Northwest seem to be particularly at risk. And finally, those in the BAME category, so Black and ethnic minorities, are significantly more at risk of contracting and sadly dying from COVID-19. So profiling our staff in a way we never have done before is probably more relevant now as part of the COVID-19 risk assessment. And then there's the social distancing. If people are required to go to work, how will we plan social distancing in the workplace? How will we regulate and enforce that in the workplace? How will we keep people separate or not face to face at desks? How will we provide PPE? When will we provide it? Where will we provide it? How will we monitor the use of that PPE? Should we be taking temperatures of those people who are required to go to work? JCB were on the news this morning and they're taking the temperature of everyone required to go into work, presumably to send those away with any high or low temperature. So this is lots of consideration needs to go on now as part of this risk assessment. The risk assessment has to be done if you're requiring employees and staff to go back to work. And this risk is brand new. And if you're thinking, as a final remark at this stage, if you're thinking about returning to a workplace as it was in February or January of this year, then you're getting this wrong. Your workplace should not look or feel like February or January of this year. We are not in a normal situation, and your workplace will have to reflect much more stringent control measures to the risk you face, Lily. I know Malcolm's going to take over now, isn't he, on health and safety and some more practical tips.
Thank you. Yes, Malcolm, over to you.
Well, lawyers are the biggest threat to reopening the economy. So said Michael Lynn, a financial journalist writing for The Telegraph. He said, "We've created a lawyer-dominated, health and safety-obsessed culture that may turn into our biggest enemy as we recover from COVID-19. When I read that, I thought to myself, well, he's probably typing away in the safety of the comfort of his home and as his wife, partner, brings him a cup of tea. And I wondered if it would be different if it was his loved one that was being asked to go back to an unsafe workplace for the minimum wage. Well, over the next 4 or 5 minutes, I'm going to try and give some practical advice in 3 areas and show that, in fact, lawyers can sometimes be the solution to a problem. Those areas are the HSE's attitude towards regulating possible shortcomings. Secondly, a quick look at RIDDOR and the reporting of COVID-19 cases. And lastly, an update for you on the criminal courts, the current way they're operating, and how prosecutions and sentencing of COVID-19 cases may be dealt with down the line. Let me deal with the first one. There are, I think, about 500 operational HSE inspectors in England and Wales. Prior to COVID-19, we all know, those of us in the trade, that over the last few years, there's been a substantial drop in inspection rates. We know that COVID-19 has had a substantial effect on the HSE's income, as they haven't been able to go to sites and they've not been issuing fees for intervention. We've had an announcement that there's going to be only a 10% increase in the HSE budget to cover COVID-19, and that also is to cover expenditure for call centres. What about cash-strapped local authorities? They're also responsible for enforcement, and they're usually the last to get money from the government. Now, for these reasons, in my opinion, regulators will be reactive, not proactive. They're going to pick their visits. They're going to take telephone calls from employees and unions' complaints, which, by the way, it shows the importance of employee relations. And they're going to respond to incidents. And in particular, if a cluster has been identified, they're going to be interested. And what are they going to be looking at when they walk in? Well, they're going to be looking at whether social distancing of 2 meters or more was possible and whether it's been implemented consistently. They're going to look at the extent to which an employer was able to follow Public Health England or other industry guidance. They'll look at the availability of hand washing facilities, appropriate signage and adequate PPE, whether any training was needed and whether it was provided, and whether there's evidence that people displaying symptoms of COVID-19 had been in the workplace and what the employer had done about it. Be in no doubt, regulators will want to be seen to be doing their job. They will issue improvement and prohibition notices, particularly on the enforcing of social distancing. Prosecutions, remember, they don't actually have to show causation. They don't actually have to show an employee has suffered COVID-19. They just need to show that there's a risk. In relation to causation, my view will be that those will be evidentially difficult cases for a prosecutor or regulator to prove. My practical tips for a regulator's visit is make sure your risk assessment is documented. The government expects, as you've heard, that businesses with more than 50 employees will publish the risk assessment on their website. Where it's not reasonably practicable to implement a certain measure, for example, inserting social distancing screening on a production line, record the reasons why that measure was not practicable and what alternative measure that you've put in place. Remember to balance the risks. You do not need to conduct social distancing in emergency. If there's a fire, evacuate safely and efficiently. Turning now to riddle reporting in COVID-19 cases. It's an important decision. If you don't when you should, you could be committing a criminal offence and be fined. If you do when you don't, you may have unwanted attention from your regulator. Now, importantly, the government has added COVID-19 to the list of notifiable causative agents under the Health Protection Notification Regulations 2010, and also under the Control of Substances Hazards to Health Regulations 2002, coronavirus has been identified as a biological agent as part of the HSE's supplementary list of defined agents. Now, the HSE has indicated that a riddle report must only be made when, firstly, an unintended incident at work has led to someone's possible or actual exposure to coronavirus. This must be reported as a dangerous occurrence. Example of that would be a lab that's been researching the virus and had an incident. Secondly, where a worker has been diagnosed as having COVID-19 and there's reasonable evidence that it was caused by exposure at work. Now, this must be reported as a case of disease. An obvious example there would be a doctor or nurse who is diagnosed with COVID-19 after treating patients with COVID-19 where they were likely exposed. Or 3, a worker dies as a result of an occupational exposure to coronavirus. Now, in my view, the majority of COVID-19 related riddle reports will arise in the care sector or within the healthcare or scientific research context. It's going to be difficult, though not impossible, to prove in other circumstances. Now, a practical tip here is when you're considering a riddle report, document your decision, especially if you intend not to make a report. Recording the reasons why a report was not submitted may prove a worthwhile exercise if any questions are asked by regulators later on. Unless it's obvious, you may wish to take legal advice. Lastly, criminal courts and their current way of operating and how the prosecutions and sentencing of COVID-19 cases may be dealt with down the line. Now, there have been 3 main effects. The courts are no different to other sectors, and therefore there's been a difficulty in implementing social distancing. No jury trials at the moment in most areas of the country as the result. They will be starting again, but it will take 3 courtrooms to run a trial, 1 for the judge, barristers and jury, 1 for the press and the public, and thirdly, a retiring room for the jury. Now, there was a backlog of cases way before COVID-19. This backlog is now critical and it's getting worse day by day. regulatory offences, particularly in the Crown Court, will not be seen as a priority. Those priority cases will involve cases of defendants in remand or involving children as defendants or witnesses. However, pleas and sentences in the Magistrates' Court may be where we see the first COVID-19 cases being dealt with. The second aspect of effect in the criminal courts is that the parties, defence and prosecution, have in effect been told to sit down and talk through a case and see if there's a compromise that can be reached. Now, at the moment, costs to a prosecutor or caution and costs are particularly popular ways of sorting a case. Lastly, in looking forward, sentencing. With regard to corporate defendants, fines obviously reflect the current turnover of a company, and also under steps 3 and 4 within the guideline, the financial step back provisions, financial and economic reality of the company is important. This could, depending on the circumstances of the company and the economic situation, mean lower fines available in the future. For individuals, the Lord Chief Justice and the courts have made it clear that courts are to consider suspended sentences due to the fact of COVID-19 in the prison service. In effect, jails are a hotbed of COVID-19. Now, what does this mean? It does mean if things go wrong and in the future you find yourself under investigation or prosecution, there is now more leeway of the prosecution, the HSC and local and councils for an alternative to a prosecution, because understandably they're going to be interested in their costs and getting the case on. Now, I thought I'd end on some good news before I turn you back to Lily.
Thank you, Malcolm. And David, finally, obviously the tragic number of deaths as a result of this pandemic is going to put huge challenges on the coroner's courts. Perhaps you could give a little bit more detail, please.
Yes, good morning, everybody. Thank you, Lily. As Lily explained, I sit as an assistant coroner, and I'm conscious that there are some people who were due to join the call this morning, and I hope you're there, who have matters that come before me. I should probably emphasise that I speak this morning not as a coroner, but as a member of the regulatory department at Waitmans, but with a lot of coronial experience. I'm also mindful that there'll be a lot of people on the call this morning for whom the coroner's court is not a familiar environment. So with apologies to those who appear there regularly, let me just take you back to basics and explain why, in the context of COVID cases leading to inquest, the problem may not be huge. Why do we have a coroner's court? What's it there for? Well, we're there to investigate deaths if there is reason to believe that the death, or reason to suspect that the death may have been of a violent or unnatural cause, if the cause is unknown, or if the death has occurred either in custody or in state detention. They're the only circumstances in which the coroner has power to conduct an investigation, and the investigation may then lead to inquest. But the coroner can only do any of those things and can only form the reason to suspect if he's made aware by a report of a body of a deceased person being within his area. And what we know is that COVID-19 is a naturally occurring disease process, and if that is the cause of somebody's death, there is no requirement for it to be reported to the coroner at all. Natural deaths do not need to be reported. So the vast majority of deaths arising from a diagnosed case of COVID-19 will never come before the coroner's court, and certainly will not lead to an inquest. There may be circumstances in which a death in which COVID is implicated in some way comes before the coroner, and the coroner's obligation then will be to carry out some initial inquiries to see whether there is a reason to suspect that the death may have fallen into one of those categories. And those inquiries in those circumstances, if the death is reported to us prior to the body having been disposed of by means of burial or cremation, would ordinarily be for a post-mortem examination to take place in those cases where there may be uncertainty as to whether the death was indeed due to a natural cause or not. And the reality, I think, is that there will be many cases in which the first report to the coroner, perhaps coming from the family, or perhaps coming from an enforcing authority, or from even from an employer, will be after the body has been disposed of on the basis of a doctor's certificate saying COVID was the probable cause of death, meaning there'll be no opportunity then to go back and undertake a further examination by means of post-mortem. So first thing to say is I don't think there are going to be that many cases in which COVID-19 is identified as the likely cause of death, which will proceed to inquest at all. Ordinarily, cases which concern deaths in a workplace setting are reportable under RIDDOR, and Malcolm's explained the limited circumstances in which RIDDOR reporting will be appropriate in COVID-19 deaths. If a workplace death is reportable, then any inquest held in the coroner's court ordinarily takes place before a jury, not before a coroner sitting alone. We already know that that will not be the case in relation to COVID deaths. They will not take place before a jury. The chief coroner has already issued guidance to that effect. The guidance reflects the provisions of the Coronavirus Act 2020, which notes that whilst COVID-19 is indeed a notifiable disease, cases concerning COVID-19 deaths will not take place before a jury. It's an exception to the existing law. So, just to take stock, most COVID-19 deaths will not come before the coroner at all. Of those that do, if they proceed to inquest, the inquest will be before a coroner alone, not before a coroner and a jury. What then will we be doing at the inquest? Well, the scope of an inquest is already defined by law. We are to establish ordinarily who died, when, where, and how. And in most cases, the question how has the limited meaning of by what means did the deceased come about their death. In certain circumstances, those in which Article 2 of the Human Rights Act, or the European Convention on Human Rights, is triggered, will be cases in which the question how takes on a broader meaning, meaning not just by what means did somebody die, but also in what circumstances did they come by their death. And that's a significant point, because in the case in which Article 2 is engaged, the conclusion at the end of the inquest may be expressed in judgmental terms. I anticipate there will be cases, particularly those where the death is said to be directly associated with activity from the state or agents of the state, in which it will be said that Article 2 is engaged. Less likely to be the case in relation to deaths of where COVID-19 is implicated, but the death has occurred in other working environments. So there may be some Article 2 cases in which the broader duty is said to apply. In any case, however, important to note that in the coroner's court we are conducting inquisitorial proceedings. It's a fact-finding investigation to find out how the death occurred. We are not part of the process of establishing either criminal liability on the part of any named person, nor civil liability and the apportionment of blame. They're not matters that the coroner's court is concerned with. We want to establish how the death occurred, whether that has the narrow meaning or the broader Article 2 meaning. So how far do we go? Well, the chief coroner's guidance, and there have been a number of pieces of guidance from the chief over the last few weeks, first of all makes it very clear that coroners already enjoy a wide judicial discretion in deciding the nature, extent and depth of the investigation in any particular case, and it will vary from case to case. A death which is otherwise from a natural cause, COVID-19 in the example that we're discussing, can nonetheless be considered unnatural if there is evidence of a culpable human failure, something which has, for example, been an opportunity missed to prevent a death from occurring. And it's likely that investigations into COVID deaths where the medical or pathological cause is natural will be focused upon establishing whether there has been some culpable human failure. But there's a clear guidance from the chief to us all, reflecting earlier case law, that coroners have to be wary about going beyond that which is properly a matter for this forum. This is not the forum for, and I quote, concerns about high-level government or public policy. And for example, therefore, questions about whether lockdown should have started sooner, whether there should have been a different approach to the provision of PPE across the whole of the NHS, for example, are unlikely to be matters for a particular coroner to consider in a particular case, simply because he won't have access to all of the material to be able to make a proper finding. And frankly, the system would grind to a halt if every coroner up and down the country sought to investigate each of those matters in that way. And of course, we would probably have some pretty inconsistent findings as well. But nonetheless, there will be circumstances, particularly perhaps in relation to deaths that occur in other environments, in commercial workplaces, for example, where the decision by employers about whether or not to provide PPE or whether or not to take other steps to deal with appropriate social distancing measures and so forth have been taken, and whether the failure to do those things amounts to a culpable human failure by individuals within the organisation or the organisation itself. The other power that coroners have, beyond investigating deaths and reaching conclusions as to how they occurred, is in circumstances where they think that there is anything revealed by the investigation gives rise to a concern that there may be a risk of other deaths, or the deaths will continue to occur, then if the coroner thinks that action should be taken, he has an absolute duty. He must report the matter to somebody who can do something about it under the Prevention of Future Deaths report regime. This, I anticipate, will be an interesting area. So a coroner may be dissuaded by the chief's guidance from looking at government policy. That isn't to say that the coroner won't have concerns about whether the government policy, which has not been thoroughly explored and investigated in this inquest, is such that there are residual concerns about the risk of future deaths, in which case one can envisage coroners writing to the Minister of State or others. Forgive me, my own phone went off, how embarrassing is that? To say that I'm having heard this inquest, I haven't fully explored these issues, but I have concerns. Please let me know what you're going to do about it. Of course, all of this is against the backdrop of there being lots of speculation at the moment about whether, and probably more likely when, a public inquiry will take place into how the whole of the system has operated in recent weeks, and whether or not at what point the terms of reference of that inquiry will be made clear, so that we can see the extent to which matters are going to be dealt with in a different forum, in which case it's not difficult to envisage we may get to a point in which inquests generally dealing with COVID-19 deaths are suspended or adjourned pending the outcome of an inquiry of that sort. So I think for the moment that's all I wanted to bring to your attention. Happy to hand back to you, Lily, now, and you can field the questions.
Thank you all very much. The questions have been coming in thick and fast. As you can imagine, there's a huge amount of questions around the area of COVID-19 risk assessments. A theme that is coming up quite heavily from the questions is this fact that previously businesses would never have to consider how their employees have got to work. The question that's arisen is, should employers now start risk assessing how employees are getting to work? Dowie, perhaps you could deal with this one.
Yeah, it's interesting because it categorically has never been within the remit of the employer to concern themselves with how their employees travel to work. And I've looked carefully at the sector-specific guidance, all 8 pieces of the sector-specific guidance from the government, which is endorsed by the HSE, and actually I can't see any mention in there specifically requiring employers to consider how employees will travel from home to their workplace. There is mention around travelling in company vehicles, which is different. So where the employer has control over the company vehicle, you can imagine travelling gangs going to construction sites in a company vehicle, for instance. That is absolutely within the remit of the employer because that's within their control. But just the daily commute from home to the office has never been within the remit of the employer, and I technically think it still isn't. However, when we talk, when I spoke earlier about profiling staff and talking about location and geography, I do think there needs to be a consideration when you're assessing risks on an individual basis like that. If somebody is having to travel from home to work on public transport, the science tells you that they are more at risk of exposure to coronavirus, and they will bring that higher level of risk into the workplace. It doesn't mean they will have coronavirus, it doesn't mean they will spread it, but I think it should be a part of a risk assessment. I think the absence of that doesn't mean that you've fallen short of the expectations. It certainly doesn't mean you've fallen short of the guidance. So you're probably going above and beyond, and I'd be interested for Malcolm's views on that. I don't, for instance, think HSE will be looking at that part of the risk assessment on a spot inspection. But I do think that it is something for employers to consider as part of their wider risk assessments, even if they're not actually required to do so under the guidance. Malcolm?
Yes, I think an employer can reasonably turn around and say in public transport, then the undertaker of the transport should be the person who's responsible for ensuring that the travel is safe. I think the difficulty comes for an employer is if they're sitting there and employees are coming in and saying, look, I've just got on the bus or I've just got on the train and I was face to face with a number of other people. I don't want to do that every day. I've got someone at home who's at risk. And I think an employer then needs to think how they're going to be able to deal with that and think of measures perhaps in place. I know some employers have set up their own, in effect, bus systems of work transport in from a city centre out to an industrial estate. And that may be a mixture of health and safety and really employment and making sure that you're keeping your employees safe to the extent that you can. But I do agree with Dowie on the face of it, there is not a, and has never been a responsibility upon an employer to check how their employees get to work. We don't sit and risk assess the employee who decides to cycle through central London to get to work. And that is a very similar position that we're in now. So that would certainly be my starting point on that question.
Lovely, thank you. We obviously have clients who are international, national businesses that have many different subsidiaries of their business. The nature of the work that each of those subsidiaries may carry out will vary greatly. In relation to the need to publish the COVID-19 risk assessments, do you have any views on whether these risk assessments in reality will take a very generic form, or will they vary depending on the regional differences for those subsidiaries, the site differences, etc.? Do you have any thoughts? Malcolm, I'll start with you.
Well, in relation to any risk assessment, as Dowie's already said, if one's looking at different sites around the country, particularly in relation to COVID-19, one has different risks. If you're sitting in the centre of a large city, which has a large area or a large number of people with COVID-19, there's that risk compared to being if you're down in the southwest, which has a very low area of COVID-19. So I don't think a company would be able to appropriately just have a generic risk assessment covering all its sites unless the risk in relation to all those sites was the same. One should be looking at the risks of a particular site and addressing that appropriately. And it's important to understand that by the government, by requiring or suggesting that these risk assessments should be published, is that will be the first port of call for the regulator who receives a telephone call to the call centre complaining about a particular site, is that they will go on and look for the risk assessment by the employer. If it's good, they may decide that they don't need to do a visit. If there isn't one, or if it's generic or unsatisfactory, well, that may well be the appropriate trigger for a regulator to attend the site. So it's in the employer's best interest to try and get this right at the first time.
I totally agree with Malcolm there. Just one other thought. The TUC, the union, are the biggest issue at the moment seems to be that the government aren't requiring enough of employers around the risk assessment, and they want to make it a legal requirement of employers to publish their risk assessments, regardless of how many employees they have. So the unions clearly see the risk assessments as the gateway to understanding what businesses are doing. And I suppose it goes back to my overriding thought on all of this. We're all learning, every employer is learning as we go through this. There is no precedent, there is no ACOP, there is no law on this. This is all brand new. And I think my overriding view is that it requires more collaboration from employer to employee and employee to employer, with the union sitting in the middle of that and helping that, as opposed to making it more difficult. I think there needs to be more collaboration between employers and staff than ever before.
David, perhaps you can.
Just a small point on different geographies. Absolutely agree with everything that's already been said, but it's not just about across different jurisdictions. For example, thinking about Waitman's portfolio, we have offices in 8 areas. In some locations, we are the sole occupier of the premises. a different risk if you're the sole occupier and you're not having to manage the movement of other people in and out of the same building than if you're a tenant in a building with some predictable movement from the co-tenants. There's a big difference if you're on a ground floor than if you're expecting your people to come in and get in a lift and go to the 18th floor in order to work, because there'll be issues around how the lifts are managed and so on. So I think actually risk assessments will need to be site specific, I think, in almost all environments.
Thank you. And David, just staying with you, a question has just come in relation to healthcare workers, and the question that's come in is, where a healthcare worker has died following exposure to COVID by nursing COVID patients, who is responsible to report under RIDDOR? Is it the hospital or is it the employer?
The obligation to report under RIDDOR would be with the employer. It seems to be in those circumstances, unless Malcolm takes a different view, as he was our expert on RIDDOR reporting. But I think it would be the employer's obligation.
No, going back to the areas I covered earlier, there is the difficulties in relation to that. There has to be, as I said, the nexus between the death and the COVID-19 before one even considers going into who reports it. But if there is an obvious correlation between the health worker and the COVID-19 death, then obviously the employer has a responsibility under RIDDOR.
Thank you. There are also a number of questions as we move away from the temporary measures to what the new norm will look like. And we've probably all seen the countless surveys in terms of everybody actually enjoys working from home and is terribly productive working from home. And employers need to look at this whole question of home working. One of the questions that has come up is, what is the company's responsibilities in respect of home working? Are there obligations on companies to put in suitable workstations? Can we all still work off our kitchen table, off the sofa? And what are the obligations on businesses to provide additional equipment if home working is going to be the new norm? Dowie, perhaps we could start with you.
Yeah, sure. We've worked with a couple of businesses on this issue, and this transcends, I suppose, health and safety law and employment law as well. There is still the obligations. So ideally, we'd have people working from home and business can continue. Obviously, that's not going to happen across every business, but that should be the ideal. But where we have people working from home, whilst we might have completely avoided any exposure to them from a workplace setting to COVID-19, it doesn't mean we can forget about them completely. We still have obligations to make sure that they work safely and securely at home, that they are safe and that their welfare is looked after, and their mental health particularly. I know the question is specifically around display screen equipment and work equipment. So the employer does still have the same level of obligations to employees working at home. There needs to be more empowerment of employees to self-risk assess when they're at home, because they know what their work environment is better than anybody else and they can control it, whereas the employer can't. So there will need to be training, instruction, information for employees to self-assess their work area. The HSE's website is really good on that point. There is a specific area around assessing working from home. So rather than go into it in detail now, have a look at the HSE's website. There is a really good flow chart and a checklist there for employers to empower employees to self-risk assess and clearly report back any difficulties, and the employers need to make probably some financial provision for equipment if that's required.
Lovely, thank you. Moving on then to mitigating actions. Again, a lot of questions have come up, and the guidelines obviously set out preventative measures that should be carried out to reduce the risk to the lowest level reasonably practicable. The question we all ask, and everybody appears to be asking, I'm going to put this to the panel in quite a wide way. What do you advise? The 2-metre rule, PPE, do you have any thoughts in terms of mitigating actions? Malcolm, starting with you.
Well, it's important to remember that PPE is the lowest level in relation to the hierarchy. And we're talking basic health and safety principles here. And the government, certainly in England, is approaching it through health and safety principles. and PPE is in effect the last resort. The approach, I imagine, of the health and safety executive is going to be, why is it that you can't keep social distancing? Is it really impossible for your employees to have the distance necessary between them? Can you, if it isn't, does that actual part of the work need to take place? And it's only if you go down those questions and each time you're answering it, no, we can't do anything, we must move to the next, that eventually you'll get down to the use of PPE. And then, of course, depending upon the job and depending upon the extent of the exposure and what you're exposing your employee to, will then require the appropriate PPE. Obviously, someone working in the healthcare sector is going to have higher requirements of PPE than someone working on a production line with someone a meter next to them. And there are other aspects that the guidance has indicated that you should be considering in any event, such as people working back to back, certainly not working face to face. And these are all aspects. So I know PPE, particularly by way of unions, is a hot topic, but it is important to remember basic principles of health and safety.
Thank you.
Yeah, I totally agree with that. I think PPE has had so much airtime, and PPE in the healthcare and social care setting has been quite rightly focused on, has been massively important. Outside of healthcare and social care, it's less important. Malcolm's absolutely right. It's one of the final things to think about. If an employer outside of health and social care thinks that face masks is the control measure flowing from their risk assessments and that will do, they've probably got it wrong. Social distancing is the absolute aim. So the science is probably telling the government that social distancing is far more effective than face masks or basic PPE. And that's why social distancing is the aim, not giving everyone PPE. It might be that you have to do both. It might be that you can't social distance and you have to rely on PPE. But PPE is not the solution in and of itself most of the time.
Can I just add one further thing to that? Face protection, if I use that terminology for a moment, that we're all expecting to have to wear on public transport. A number of these are going to be homemade from torn up t-shirts, etc. That in itself may cause a risk within the workplace, depending on the type of work an individual is doing. So again, that needs to be considered within the risk assessment. And my tip is, in relation to these risk assessments, go through and document your reasoning behind it to make sure that if there is a query from a regulator or from an employee or a union, then you're in a position to be able to set out your thinking and the reason that you come up with the control measures that you have.
Thank you. Just coming back to riddle reporting, we've just had a question that's asking, is there any current guidelines by the HSC in terms of how quickly they will attend and assess a situation where a COVID-19 riddle report has been completed? And the second question is a business allowed to continue to work until the inspection takes place, or should they stop the business operation? What are the mechanics around riddle reporting?
If I take the first one, and as that question was being asked, a small smile was beginning to appear on my face, because before COVID-19, it was not unusual for there to be a substantial delay between a company reporting an incident via riddle and then receiving a visit from the regulator, or on a number of cases, not a visit, but an email or a telephone inquiry. So in answer to the first part of the question is, no, there is no time limit in relation to that. I fully expect that the call centers from that are being set up and will be covering the health and safety executive and local authorities, because don't forget they're also a regulator for a large proportion of what is going to be opening up over the next few months, will be inundated with calls. And they're going to have to realistically prioritize those controls depending on the risk that's been identified. So in answer to the question, no. And I can quickly answer the second part of the question. The answer is simply no. The fact that you've made a riddle reportable report does not mean that you have to stop. I would, however, advise that if there has been a RIDDLE reportable incident, you should be, as a good employer, going back, reviewing your systems, seeing what's happened, and if necessary, implementing further controls.
Lovely, thank you. Just looking further at the enforcement point, in reality, how are regulatory authorities going to prove that somebody was injured in the workplace through exposure from COVID-19? Are there any thoughts of the impossible question?
Do you want me to go first, Malcolm? And
yes, please,
yes,
thank
I've
you.
been talking a lot, in fairness.
That's okay. So the question was around proving exposure to COVID-19. Yes. Well, they don't need to do that. So the HSE don't need to prove exposure to COVID-19. They don't need to prove that someone's got COVID-19. If someone has COVID-19, they don't need to prove that it was exposed to or contracted in the workplace. It's around measures being taken to reduce the risks to people's health and safety and welfare to the lowest level reasonably practicable. And whether that's successful or not might be relevant, but it doesn't dictate whether the measures put in place are adequate or not. So the HSE do not need to reach that level of threshold. They don't need to prove exposure to COVID-19 in the workplace.
Thank you, Dave. David, another question that's just come in this moment, which perhaps you could help us with, is there a possibility of unlawful killing conclusions based upon corporate manslaughter, even if the police have not taken action?
I think David's lost his microphone.
Oh, have we lost David? David, can you hear us?
He can hear us, but I don't think
we just can't hear us.
Him.
What was the question, Lily?
Is there a possibility of unlawful killing conclusions based upon corporate manslaughter, even if the police have not taken action?
So this is at Coroner's Court.
Yeah, we might wait for our.
I think the answer to that is I can say from experience as someone who also appears in the Coroner's Court, but not to the level that David does, but as an advocate, that there are circumstances I've had in the past, not COVID-19, where the police stroke CPS have looked at the homicide, decided not to prosecute, and the matter has been handed back under the protocol to the Health and Safety Executive. But as a result of what happens in the Coroner's Court, then someone like David will either write a report or leave it open to a jury, and a jury can conclude a homicide conclusion. Or, as it happened to me, halfway through an inquest, the coroner stopped it and then said that from what he had heard, he had to pass it back to the police and the Crown Prosecution Service. And 2.5 years later, one of the individuals involved in the inquest was convicted of manslaughter and received a 2.5-year sentence. So in answer to the question directly, the answer is yes, but it is unusual.
I seem to be unmuted again, so apologies everybody for that. I've lost my screen with the ability to unmute, but I'm back on. Thank you, Stacey.
Thank you.
I mean, I agree with what Malcolm just said. The practical point on this, I suppose, is that I anticipate that unlawful killing proceedings will be very difficult in these cases, because there will always be arguments around causation and whether or not the COVID-19 was contracted in the circumstances in which the human failure was being alleged, or whether it may have been contracted by transmission just in the community or elsewhere. And the probable absence of post-mortem reports in many cases will also mean, I think, for prosecuting authorities, it will be very difficult to establish the requisite causal connection between the death and the culpable act to the criminal standard. And of course, in order to return a finding of unlawful killing in the coroner's court, one would need to be satisfied to the criminal standard that an offence of murder, manslaughter or corporal manslaughter had been established, and it would have to be safe to reach that conclusion on the basis of the evidence you've heard. So it seems to me to be theoretically possible, but improbable that would be an outcome.
Thank you. Again, a question and a theme that's coming in quite heavily from those attending is this issue of the approach that the HSE are going to take. They've obviously said that they'll be taking a flexible and proportionate approach to the risks arising from COVID-19. But how likely do you all think it's going to be that they're going to go beyond issuing enforcement notices and genuinely be considering prosecution? Any predictions?
Yeah, well, I think the chief exec changed things. The chief exec of the HSE didn't like change things when she said there will be prosecutions for failures to comply, because up until then the approach had been fairly soft from the HSE. I think a couple of things concern me as primarily a defence lawyer. They have had more money pushed into the HSE to support regulation and enforcement of COVID breaches. So they've got a 10% budget increase purely to support spot inspections and the use of enforcement notices to enforce breaches or apparent breaches, and then they will prosecute any continuing breaches. I think what concerns me is if they are really concerned that a business is not understanding what is required of them, they will use a prohibition notice to shut them down in the short term, rather than take a risk with an improvement notice. That's what really concerns me, and that seems to be the mood music coming out of the HSE at the moment, but we'll just have to wait and see. I think all of these things will hit the news very quickly, whether that's the formal news or social media, so we'll find out informally or formally through those means.
I can just chip in a view, not as a coroner, but as a health and safety lawyer. I think it's almost inevitable that we will see some prosecutions, but I think they'll be targeted at those whose level of culpability might be thought to be very high, those who've either deliberately not tried to comply with the law or have acted so superficially in attempting to address risk and manage risk that they've effectively just made no realistic attempt at all. I think it improbable that organisations who have done their best to heed the government advice and guidelines and to follow it, even if they're shown to have fallen short at some point, I think my guess is it's improbable that they will face prosecution, simply because there'll be so many, I suspect, who will be in that boat. But those who haven't made an earnest attempt to apply the principles that the government set out in the guidance, I think will certainly be on the receiving end. And the likely, just back to sort of linking this with the question about how often will HSE come around or local authorities come around and inspect, I think it's direct complaints from employees, whether you want to call it whistleblowing or whether you just to regard it as direct reporting, that are likely to be the trigger. As is always the case in any health and safety matter, it's your own employees who know the truth and tell the truth. And if you're not doing it properly, they will tell on you.
I think David's got it spot on. I think David's got it spot on there. And I think what is going to be interesting is the view the HSE take between the individual responsibility of an employee and the how they approach businesses. Because I think in relation to individual employees, I think it will be much like the police, guidance, not enforcement. But when it comes to systems and it comes to businesses, then as I'm afraid they frequently do, they like to pick the low-hanging fruit. And so where a company has received a warning or where there have been incidents before and nothing done, then that is an obvious aspect for prosecution. As Dowie previously said, they don't have to show that there's been an injury, they don't have to show that there's been a death. All they've got to do under the Section 2 and Section 3 is to show the risk. So that will be, I think, their approach. They're going to be very busy, but there may well be aspects of businesses that they particularly wish to make an example for. If they're, for example, in the construction industry, and I'm just picking this construction, if they decide that there is a failure within the construction industry in relation to social distancing, they will be looking for an example case to make their point.
Can I just add one further thought, and I don't know the answer. We could probably do with an employment lawyer to help us with this, but it will be interesting to see the extent to which employers criticise, even if they've put in place the right measures, for failing to deal with employees who then don't play their part by following those measures. So if an employer says, I insist upon social distancing, I've introduced a one-way system, only one person can go to the gents at a time, so you're not standing close to each other at the urinals, whatever it might be, and then employees themselves ignore those rules and the employer doesn't take action to address it. that will be an interesting.
I think, David, it'll be that. I think it'll be that failure to take action and to enforce that the HSE will be particularly interested in, and it's going to be difficult because we can all walk outside, we can all see people who are meant to be social distancing, and some people who think they're social distancing, but it is a natural human response to get close to those that we talk to and those that we know, and it is very difficult, which I think is perhaps when businesses are looking at this, the physical barriers can be so important. The physical barriers between employees, the marking of the workplace and the one-way systems, because that goes against the human nature and helps to enforce social distancing. But it is very hard.
Just for the reassurance of our audience, I think of the four of us, Dewi and I are probably the closest at the moment to 10 miles apart as the crow flies, so we are socially distancing in exemplary fashion. Sorry,
Lovely. Thank you all. I'm very conscious of the time. As is so much in this changing climate, there's clearly going to be an element, and the theme that comes out of our discussions and everybody's discussions when it comes to this topic is it's very much a wait and see how the things play out. I am really grateful for everyone attending today. Apologies that the 1 hour slot meant that we've not been able to get through everybody's questions, and clearly there are an important number of issues that you will want answers. We're fortunate that the national team, we have been advising clients over the past couple of weeks on topics that will be relevant to every business from a more bespoke nature, and we are very much available to provide you with that more detailed and more confidential advice. So please don't hesitate to get in touch. There will be a follow-up by way of a questions and answers session, and we will deal with all of those queries that we've not been able to deal with today, and please don't hesitate to get in touch if there are any more confidential questions that you'd like us to deal with. But I am really grateful for our expert panel today, and I'm really grateful for everybody attending, and please do take care. Thank you.